Right. Good morning, everybody. Before we start, I need to make everybody aware that we are on webcam, and if people want to look at the webcam later on, it will be on the website. In terms of COVID, we've got the doors open. We haven't got masks on, but we're all speaking, and we're all quite well socially distanced as we should be. So we'll move into the meeting itself. It's 10th of December, Countryside Rights of Way panel. Have we any apologies?
Good morning, Chairman. No, we're not in receipt of any apologies.
Okay, thank you. And I think we're all here anyway, aren't we? Right. So moving on to item number 2, declarations of interest. Has anyone got any declarations of interest on this? No? Okay. And item number 4 is the minutes of the meeting of the 8th of November. Can I just, it does say here, 8th of November 2019.
We've got two items, Chair. One number 3, which is the minutes of the last meeting, and then there's a mistake on the minutes of the 9th.
Right. So the minutes of the 12th of November, can we look at those? Are we happy with the minutes of the 12th of November? Yeah. Okay, we've moved them and agreed with that. Okay. And then on the 4th, item number 4, we've got, again, is that minutes?
It's a correction. Mick Murphy's been talked to.
Right, okay. Do you want to talk to that before we talk on the main agenda?
Yes. Yeah.
Okay.
It's been drawn to our attention that the minutes of the 2019 meeting in relation to one of the applications, item number 119, which is, from memory, the Keel application that we deferred. The minutes say that it was deferred because of additional material that the applicant sent in. That's not the case. It was because of material the landowner sent in. We just need to note it. There's not much we can do. We can't really go back and change things because the minutes have been signed and approved. But we have told the applicant that we will bring it forward at the panel and mention it to members so that at least the error is recorded for future if it's required. It was put as applicant instead of landowner.
So it's really a correction of the minutes that has to be noted here. Paul?
Is this a matter that's going to appeal, judicial review or anything, or is it just purely they want it amended?
No, it isn't, Councillor Snape. The matter is still got to come back to panel, which we hope to do in January. All things being equal, I'm not going to guarantee, but we hope to bring it back in January. But there's no anything else about it. The applicant just drew it to our attention as an error, and I must admit that I didn't notice. It's one word. And, you know, you get word blind sometimes. So
Yeah, we do need to just sort of propose and second that we've had the information. Proposed by David, seconded by Paul. Do we all agree? Thank you. Now, before we start item number 5, which is the first application to be heard today, Mick wants to say a few words about the applications. Thank you.
Thank you, Chair. First of all, you will have noticed from the reports that they've all got the same reference number and they're all in the same area. I'd like to explain why that is. In the dim and distant past, The habit was, with these applications, if they came in close together and they were for the same area, they simply opened one file. So in this instance, there are 5 routes in industry, and they opened one file for those 5 routes. We've had other applications where we've got 3 routes on file, and Chebsbury, for example, there's 4 routes on file. It's not that there aren't separate applications, it's that they've all been put into one file, which is why they've got the same reference number. In this instance, Mr. Ray did make a separate application for each route. He's made a separate Form 1, and we've divided them up accordingly, which is why you've got the reports that you've got in front of you. The second thing I would like to say, we've had some representations, and one of those representations relates to item 6. We've been informed that there may be a possibility that we haven't notified or contacted every landowner. We can't say that we have, and we can't say that we haven't, not without doing some more extensive checks just to make sure. So what we would like the panel to do is to defer this one so that we can do some more checks to make sure we have notified every landowner. There are a lot of landowners on this particular section. I think it's, was it 15, 16? Yeah. So we want to make sure that we've notified everybody so that there's no procedural problems and everybody knows about it. I mean, the application has been discussed and researched and everything by most of the landowners around there. We did discuss extinguishments and diversions with them and the parish council. So it's not as if it's a surprise, but one never knows. We may have missed somebody off. It happens when human beings get involved in things, errors get made. So I know what we said last time, and we adopted a policy that we wouldn't defer unless, we had to. But I would ask the panel that if we can defer this one when the item comes up. Okay. Okay. And one final thing, I'd just like to introduce you to my new boss. This is Heather Morgan. She's taken over as the team senior for Rights of Way. And in the immortal phrase of the bard, the buck stops there. But no, she's taken over. She has got Rights of Way experience from some years ago. She used to work with me. I'll let her introduce herself. I don't know why I'm talking.
So, hello, I'm Heather Morgan, and I was appointed in October as the team senior for the Rights of Way legal team. So I do have Rights of Way experience from some years ago, and I'm also a highways specialist, and I have been and I've got sort of around 20 years experience in highways law, so I know the area of work well, and I also understand what challenges it brings. There isn't really much more to say. I'll lead the team as best I can with the knowledge and experience that I do have, and we'll go forward and just carry on with the work that we're doing, and I'm hoping that my experience and knowledge will help the team to develop going forward.
Thank you both. Before I bring David in, can I just reassure members that Mick's not going? I think that was his Christmas joke. Would you like to tell members that you'll still be here?
Yeah, I will still be here, and I will probably be the one that comes to panel. Heather's got a lot more responsibilities and things to do. Besides Rights of Way, she does do other things, as do I. But she's going to be taken up with doing other things, and I'll still be coming to panel for as long as I'm still here. Yeah, a nice codicil.
Yeah. Thanks, Mick. Right, David.
Yeah, Chairman, could I just welcome you to our panel and hope we have a long working relationship. I hope that you're going to be able to wave a magic wand and dispose of all of the backlog that we've currently got. And may I also, Chairman, just mention the point that I raised with you about HS2. You may be aware, but we had a coordination meeting with HS2 on the progress of the project. We have these things quarterly, and it was raised about public rights of way and things that they were doing, some things under the Act and some things they'll need to bring to the panel. We do have a standing item on the agenda when things need to be brought forward, and I think probably for our next meeting there may well be a lot of stuff that we need to be briefed on, and so I'll just run up a flag on HS2. Thank you, Chairman.
Okay, thank you for that. I'm not sure that I have a magic wand, but I will do my best. But thank you.
Thank you. Now, Jill.
Thank you, Chair, and I'd like to welcome you as well. Thank you. Can I just ask Michael about the point he made in reference to item number 5, where we've got one file with 5 routes and 5 numbers?
Jill, would you just say that again, but
Sorry.
closer to the microphone?
Sorry. It's a question for Michael, actually, the point you made about the one file with 5 routes, so we've got 5 different numbers. Is that a good practice? Are you going to review that going forward? It is confusing. Thank you.
It's not the sort of thing we would do now, Councillor. If we get an application in, we open one file per application. That makes more sense, really. But why they did this all those years ago, I've no idea. Certainly since 1999, when Bridget and I started, we've continued to make individual files for each application. We may, on occasion, work on 2 applications together because it's the same evidence and it's the same area and what have you, but they are separate. With these, no, it's not good practice. I agree, it's not good practice. But it's such a long time ago. Can't say why they did it, but it just seems to have been a thing that they did.
Thank you, Chair. So it's not happening now then? That's good, thank you.
No, we don't do that anymore.
Okay. Now, just so the panel knows, and I'm sure possibly you've had the same, I've had quite strong representation from the local council, county councillor John Francis, and also a letter from the parish council. And the points made have been taken on board, and sadly John Francis can't make it today, else we would have had quite a strong representation from John in his own fashion. I would just, rather than wait until the next application, can we just all agree to take item 6 and defer it till a future meeting? Yeah, everyone agrees with that. Okay.
I've had no representations at all made to me, just for the record.
Now we've done that, has anyone else had any representations? No. Okay, so they've all been registered. Okay, we'll move back to the agenda, and item number 5, which is the Wildlife and Countryside Act 1981 application for an alleged public bridleway between Trent Walk and Fiddler's Lodge. Who's going to take this?
That's me, Chair.
Okay, thank you.
Okay, thank you. So this particular application is in relation to the addition of a public bridleway, specifically between Trent Walk and Fiddler's Lodge, which is marked A to B at Appendix B in the parish of Industry. So as already said, the application was submitted by Mr. Martin Ray. So in support of the application, the applicant submitted a quarter session order dated 1801, and a plan for diverting a highway in the parish of Industry. So the quarter session order basically sets out a diversion which also appears to have stopped up a length of bridleway that passed in front of Industry Hall. And it turned the bridleway onto a new line, leading to a point on the Stafford and Utoxeter Turnpike Road, which is now currently the A518 Western Road, near to the county showground. So Western Road was at the time of the order part of the Turnpike Road from Stafford to Utoxeter. So from the quarter session order, it appears that a length of 739 yards of the old bridleway was to be stopped up. So this section specifically being from Dog Kennel Gate to Tixall Park Gate. So the bridleway was to be diverted onto a new line which took the bridleway from the end of Dog Kennel Gate in a northwesterly direction and then looping round to terminate on the A518, as already stated, where the land is now occupied by the county showground. So this new route was to be 2,626 yards in length, and this falls on the same line as the alleged route. So the Earl Talbot, in a deposition, consented to the new bridleway going through his lands, and that he would have the land that the old route ran over. He also confirms that he will maintain the new bridleway, and there would also be the erection of a public bridle bridge over the River Trent, which the Earl would also maintain. So a certificate of completion accompanies the order stating that the justices were satisfied that the new bridleway was fit for purpose. In relation to the map with the Industry Estate Diversion Plan, this is not to scale, but it does show the various roads in the area, including the way from Trent Walk. So following initial consultation regarding the application, the Ramblers Association responded, advising that they believed the route should be added to the definitive mapping statement because it would provide a direct link to existing bridleways across the Industry estate. They stated that it links to a bridleway that had been recently created as part of a diversion of public footpath 19 in the parish of Hopton and Cotton. At the time of the initial consultation, Stafford Borough Council also responded, stating that they had no comments to make on the proposals. So going back to the quarter session order, the authenticity of the order has been verified by officers, and it's also been examined by a Dr. Fawkes, who is a consultant archivist and historical researcher. Dr. Fawkes confirmed that a stretch of bridleway was to be stopped up and along a section of route substituted through the Earl's land away from the hall. So the combination of the order and the plan do provide a fairly accurate description of the path intended to be diverted and the line of the new bridle path. The order clearly sets out that the old bridleway is to be diverted and turned in consideration for the new route. So the order plan shows that the diverted route would go past Birch Hall Farm towards and past the old Lodge Covert through to Hopton Heath, where it joins the Stafford to Utoxeter Turnpike Road. So the consent from the Earl suggests that his intention was for there to be a network of bridleways. The fact that this is a quarter session order does mean that it has legal effect. So the time to challenge the order would have been when it was made. So in the absence of any such challenge, and given that it was subsequently confirmed, it does have legal effect. No orders or other documentation have been discovered to suggest that the new bridleway between Trent Walk and Fiddler's Lodge have ever been the subject of an order extinguishing any public highway rights. So in the absence of contrary evidence, the order does provide strong evidence that the public bridleway still exists. Therefore, the effect of the order is that the diverted bridleway from Trent Walk to Hopton Heath remains as a public bridleway. There is also relative accuracy with the order map when it is compared with the current road layout as shown in Appendix E. The industry estate diversion plan does show the routes that cross the Earl's lands and which were diverted as part of the order. So usually on its own, this type of plan would not provide much evidential weight, but when considered alongside the 1801 order, it does show the intent to create a new bridleway and that this was carried out as an order was sought by the justices. In addition to this, in 1995, an order was made to create a length of bridleway in the parishes of Hopton and Cotton, and also industry with Tixon. So the length of bridleway commenced at Fiddler's Lodge at the A518 at Stafford and connected to public footpath 18 in the parish of Hopton and Cotton. So this route was then diverted to the county showground. So at the time the diversion was made, no objections were made in relation to the order, and Staffordshire County Council was satisfied that the bridleway existed despite not being on the definitive mapping statement, and therefore proceeded to divert a non-definitive way. So the order could only be confirmed if Staffordshire County Council were satisfied the bridleway existed based on the balance of probabilities. As it was confirmed, this must have been the case. So there was no evidential material submitted an objection, nor any evidence discovered which would suggest that the quarter session order had been overturned or that it never came into force or to refute it in any way. So there were no objections from members of the public also regarding the proposal. So if the council were satisfied that this section of the bridleway still existed based upon the quarter session order, then that must apply to the entirety of the route. So the route that is subject to this report, so the route running from point A to point B at Appendix B as the route does connect. So this does also add further weight to the existence of bridleway rights along the alleged route and also the evidential value of the quarter session order. Following circulation of the report, comments were received from the landowner of Birch Hall Farm, Mr. Taverner. He argues that it is difficult to accurately determine what occurred under the 1801 order and the exact location of the alternative route discussed in the order. And he is of the opinion that the route has always been private. Mr. Taverner's comments have been noted, but officer's opinion does remain that the 1801 order does adequately confirm the line of the alleged route and the nature of rights over the alleged route. So given the legal effect of a quarter session order, and given that it could only be overturned by another legal order, the order does, on the balance of probabilities, provide strong evidence that a public bridleway does exist along the line of the alleged route. There's no further evidence of a further legal event having taken place that overrode the 1801 quarter session order or that it did not take effect. So therefore, when taking into consideration the relevant legal test, it is officer's opinion that the application has passed the test on the balance of probabilities, and therefore a public right-of-way with the status of bridleway does subsist. So thank you, and happy to take any questions.
Thank you very much. We've got no Speakers against or for the application? Members, any thoughts? Paul?
It looks as this case really, it's one of the most straightforward that we've come across for a long time. If you look at the quarter sessions order 1801, I mean the quarter sessions are what came before the Crown Court, so it's a high order. It was then certified by the justices, and that was never rescinded because that has to go back to court to be rescinded. It never was. The landowner, Earl Talbot, consented to it before it went in 1801. So really, I think the evidence is there, definitely on the balance of probabilities, probably even higher than that, really. But I will gladly propose that this goes through as the points A to B, as in Appendix B.
Yes, thank you, Chair. So as stated, this again is an application for the addition of a public bridleway in the parish of Industry. So in relation to this application, the route is marked from E to F at Appendix B. Again, as with the previous application, this was submitted by Mr. Martin Ray. So again, with this application, Mr. Ray submitted in support of the application the 1801 quarter session order and industry estate plans that were also subject to the report just discussed. So as always been stated, the quarter session order sets out a diversion which appears to stop up a length of bridleway that passed in front of Industry Hall. So the original route passed in front of Industry Hall from Dog Kennel Gate to Tixall Gate and then past Hanyard terminating at Halfway House. So that is the route subject to this report and includes Hanyard's Lane, which is included in points E to F on Appendix B. So as already mentioned, the order refers to a length of 739 yards of old bridleway to be stopped up. Again, this is specifically the section from Dog Kennel Gate to Tixall Park Gate, which was in front of Industry Hall. So the Earl consented to the new bridleway, and the land over which the extinguished park crossed was given to the Earl as compensation. So as stated in the previous report, Dr. Fawkes reviewed the 1801 order, and in relation to this part of the route being discussed, stated that the bridleway from Littleworth to Hanyards was not affected by the order, and therefore presumably continued as a bridleway serving Hanyards. So this supports that this section of the route was not stopped up and did continue to act as a public bridleway for members of the public to use. So no orders or other documentation have been discovered to suggest that the bridleway from Hanyard's Lane, which includes Hanyard's Lane itself, to the Stafford Road have ever been the subject of an order extinguishing any public highway rights. So although the order does refer to the length of bridleway being stopped up, it's not clear that this took effect and members of the public stopped using it. So therefore the order is supportive of there being bridle rights over the whole of this section of the alleged route. So following circulation of the report, comments were received from Industry Golf Club and International Design Group Limited, who are Industry Golf Club's course architects. They've advised that if the application is accepted, it could breach safety guidance, as the holes on the golf course potentially will be too close to the bridleway, and then there is the possibility of stray golf balls causing potential injury. So as stated in our letter of response to the golf club and the architects, whilst it's not our intention to belittle any concerns raised, the courts have confirmed that issues relating to safety, suitability, privacy or maintenance, or basically anything other than material relating to the existence of a public right-of-way do have to be disregarded under the law as it currently stands. Also, we did receive comments from industry with Tixall Parish Council who have raised objections to the application. They've raised concerns about the accuracy of the documentation submitted with the application and the impact that the proposal will have on local residents. We've also been contacted by Sandwell Council, who own Industry Hall. So they run Industry Hall as a residential educational facility for children, and they have raised concerns that if the route becomes a public bridleway, this could have impacts on child safety issues, with members of the public accessing land used by children, and therefore they object to the proposal. As already stated, whilst we don't want to kind of belittle any concerns raised by anyone, particularly regarding children, the courts have been clear as to what issues can be taken into consideration when establishing whether a public right-of-way exists or not. And Sandwell Council have been advised of this. So when the evidence is reviewed in totality, the quarter session order does support the existence of public bridle rights over the whole of the alleged route, and there is no conclusive evidence that any part of this alleged route was stopped up. Therefore, it is officer's opinion that a public bridleway exists along the line of the alleged route. So thank you again. I'm happy to take any questions.
Thank you. David?
Presumably, we're in a cleft stick situation, regardless of the health and safety or whatever else, that we have to, subject to committee agreement, if we make the approval, we have to take the evidence as it is presented to us. But if the objectors are saying that this is a safety issue, they would then have the opportunity to apply for a redirection of the route, which we would presumably be able to consider as a matter of priority. I mean, we have our duty to do, and they've got their health and safety to consider.
Paul?
I agree with David's point about redirection, but if there's a golf course there, it's their job to make sure bulls don't affect the routes. Fences, whatever it's going to be. I mean, I've got, on my division, I've got walks there, there's golf courses, but they've got big nets, fences up, so bulls don't go onto the routes. And exactly the same for the child safety issues. The legislation is quite, well, the stated case on the matter say they are matters we can't discuss or we can't take into consideration. So if it does come back, I'll gladly support a change in direction of the thing, but at the moment we can't look at it that way, as David has said.
Thank you. Jack, did you want to speak? Okay. Yes, I mean, this isn't safety is not one of the issues in terms of definitive right of way, and it is for a further hearing or whatever to discuss that. That given, have we any proposals? proposed by Paul Snape, seconded by Jack Abrahams. All in favour? Unanimous. Okay, thank you. Thank you for your time and presentations. We'll now move on to item number 8, which is exclusion of the public. And I do have to read out that the public be excluded from the meeting for the following items of business, which involve the likely disclosure of exempt information as defined in the paragraph of Part 1 of Schedule 12A, brackets as amended, of the Local Government Act 1972, indicated below. Thank you. Can I thank the officers and members for the meeting we've had so far? Thank you.